Hello, welcome to Free Speech Unmuted. I'm Jane Bambauer, Brechter, eminent scholar and professor of law at University of Florida.
And I'm Eugene Volokh. By the time this is put online, I will probably be a senior fellow, or at least a day or two away from being senior fellow at the Hoover Institution, and I will be emeritus at UCLA Law School, where finishing up 30 years of teaching. But the really interesting thing is we have a special guest. Who is this special guest? Erwin, who are you?
My name is Erwin Chemerinsky, and I'm Dean and Professor at the University of California, Berkeley School of Law.
And not only a Berkeley professor, you had for a long time been city mate of ours at USC Law School, and then at Duke Law School, and then the founding dean at UC Irvine School of Law. So Erwin is an august personage in constitutional law circles, is the author of many articles and treatise, and in general knows a tremendous amount about constitutional law, and yet despite that went on to become a dean. So no, I think it's tremendously important that top scholars are willing to become deans. I would certainly never want to do that. I'm shocked that anybody would, but I'm delighted that people are willing to sacrifice to that extent to become administrators. So Erwin, I wanted to ask you, we're going to be talking in part today about academic freedom and professors. Erwin is the co-author of a book on academic freedom generally with Howard Gilman, and he's certainly thought a lot about the legal issues involved in the academic freedom rights of professors inside the classroom, outside the classroom, and such. But before that, there's just so much in the news about student speech that we felt we had to, even though our last episode was about that, to add a bit more on that. In part, Erwin, there was an incident involving students who seemed to think that they were entitled to speak in your backyard, literally in your backyard, at a party that you had put together for Berkeley students. Tell us whatever you feel comfortable about what's going on there, kind of what happened, what your reaction was, what the institutional blowback has been, and what you think this tells us about free speech at the modern university.
Let me just say what a pleasure it is to be in a conversation with both of you. My wife and I have been doing dinners for first-year law students at the start of their law school career as long as I've been a dean. However, in the fall of 2020 and the fall of 2021, we couldn't do those dinners because of COVID. Last year's graduating class that had begun in 2020 asked us if we would do dinners before commencement for them, and we did. And then this year's co-presidents, the third-year class, came to us and said, you didn't do dinners for us in the fall of 2021. You did dinners last year's graduating class, would you do them for us? We agreed to do dinners on 3 nights, April 9th, 10th, and 11th, and students could pick any one of those nights to come to dinner. On April 1st, a week before, a flyer went up on all of the bulletin boards of the law school and online. It had a caricature of me holding a bloody knife and fork with blood around my lips, calling for a boycott of Zionist Chem's dinner. It didn't have a complaint about anything I had said or done. I've taken no position and made no public statements about what's going on in the Middle East. It's not my field of study. The only demand was that UC divest from Israel, which, as you know, isn't in the control of the law school or the campus. It's the regents. That Thursday, the co-presidents of our student government came to me and said that the Students for Justice in Palestine that had put up the flyer demanded that we cancel the dinner, and if not, they were going to protest at them. I said we weren't canceling the dinners. Those who don't want to come, of course, don't have to, but we wanted to have them for those who did want to attend. And so long as they protested peacefully in a non-disruptive manner, that was their First Amendment right. And I assumed it meant they would picket in front of our house, and we had someone there just to make sure that they didn't come onto our property if they did that. The dinner was on April 9th. I was surprised to see the leaders for the Students of Justice in Palestine, who had called for the boycott, come to the house. We greeted them warmly. Everyone went to the backyard, sat around for a half hour or so before dinner. Everyone got their food. And then just as people started eating, the leader for Students for Justice in Palestine, the person who was responsible for the flyer went onto the steps of our backyard with a microphone and began to read a speech from her cell phone about the plight of the Palestinians.
Hello, everyone. Assalamu alaikum wa rahmatullahi wa barakatuh. Peace and blessings upon you all. Tonight, we are gathered here in the name of commemorating our final few weeks as law students.
This is my house.
Tonight is also the last night of the holy month of Ramadan, where millions of Muslims around the world fast, not only from material sustenance,
not only from material sustenance. We have attorneys. We have attorneys.
Okay, you don't have to get
Excuse
aggressive.
me.
I'm not
Please leave our house. You are guests at our house.
This is our First Amendment right.
No,
This is our First
this is
Amendment.
my house.
It is. The National Lawyers Guild has informed us this is our First Amendment right, and they are aware of this. They're not wrong.
This is my house.
This is my house, and you no longer. I immediately got up and said, "Please stop. Please leave." She didn't. At one point, my wife grabbed the microphone. The student, by the way, brought the microphone. We don't have any speeches at these events. There was no microphone. The student said, "If you let go of the microphone, we'll leave." And 10 students left at that point. It was enormously sad to see the anti-Semitic flyers all over the law school, though I felt I could not take them down from the bulletin boards. It was enormously sad to have a dinner at my house disrupted in this way. The student, as part of the exchange, said, "We have free speech rights to be here and do this." And of course, as you know so well, even if it were in the school, it would be what would be called a limited or non-public forum, and there's no First Amendment right to disrupt. But there's certainly no First Amendment right to do this in our backyard. A video was taken of it. An excerpt of the video went online. It went viral in a way I could have never imagined. We, for many days, received death threats, thousands of hate messages, as well as supportive messages. And the fallout continues. I'll answer anything you want to ask about it, but that's the short version.
So the first message that we should all learn from this is no good deed ever goes unpunished. Erwin, I should say I entirely sympathize with your position on this. And I do think it's important that, as you pointed out, even if this were a dinner at the law school, there are reunion dinners, for example, at UCLA Law School that are held in, maybe it's sometimes in the library or even in some internal courtyard. That's not an occasion that people are entitled to get up and start orating. But tell us a little bit more. One thing that I've heard in the news is that the university has started an investigation of you, or perhaps your wife, or both. Your wife, of course, is Catherine Fisk, who is also a leading scholar, in her case, a scholar of labor law, for supposedly mistreating the student by trying to take away her microphone. If you feel comfortable, can you tell us about that?
The student from our backyard, who's also the one responsible for the anti-Semitic flyer, filed a complaint against Catherine with the Office of Prevention, Harassment, and Discrimination on campus, alleging that Catherine acted against the student because the student is Muslim and Palestinian, and that Catherine had acted inappropriately by grabbing the microphone and inadvertently touching the student. The Office of Prevention, Harassment, and Discrimination, a week ago Friday, said that it was investigating this. The student then went to the press and gave the press the letter which led to the story that Catherine is being investigated.
Now, were they under an automatic obligation to investigate, or was there some sort of decisional choice at that point?
Well, they always have a choice whether to investigate. I understand there are a number of instances each year, a significant fact where they choose not to investigate. So implicitly, they made the choice that this is worthy of investigation.
Yeah, and for listeners, if you are curious, there is some footage online. You can look and see for yourself what happened, but it is, from my eyes at least, exactly as Erwin described it. So I have a question. So it seems like it's not surprising, especially given your knowledge of First Amendment law, and also just your straight spine and great integrity, that you weren't willing to, that you didn't it probably didn't even occur to you, or you certainly were not going to take down the flyers, as offensive as they were. And you also invited these students into your home to give them a chance at least to do the right thing, right? That all makes sense. I'm wondering if the flyers had targeted either a faculty member or a student instead, how would you have treated that case?
Let me also say, I received a number of requests from Jewish staff and students to take down the flyer. It wasn't a flyer on a single bulletin board. It was they put multiple flyers on every bulletin board. And the response that those staff and students gave me was, it made them feel unsafe to have that caricature that was anti-Semitic. And my response was, since they posted them in accord with school rules for posting things, I couldn't, consistent with the First Amendment, take them down. If it had been about anybody other than me, I would have sent a message to the community condemning them. We had an incident a number of years ago when Alan Dershowitz was speaking, and someone drew a swastika over a picture that was on the bulletin board. As soon as I saw it, I sent a message to the community condemning it as being inconsistent with our values. I didn't feel comfortable doing it in this instance because it was a caricature of me.
Right. At some point, if it had been a student, maybe just pushing it even further, at some point, would you have found your obligations as a dean to manage harassment to outweigh or to have to even come into direct conflict with the First Amendment values?
Of course, and there's always the tension, and maybe we can talk about it, between the Title VI obligation to prevent harassment and the First Amendment obligations for a public school. There are many ways of meeting the obligation, and one of them is for administrators to speak out and condemn things. Another is to provide support for those who are being targeted. The key is, I think, in order to meet both obligations, is that a school can't be deliberately indifferent. And as I said, in this instance, it was different because it was a caricature of me, and I didn't want to be seeing the act out of self-interest in protecting myself.
So, Erwin, if I could turn to another story that's in the news, thankfully at this point, does not include Berkeley, although given what's been happening at UCLA, maybe it will soon include UCLA, the school that I'm still going to be affiliated with as an emeritus professor. This one involves Columbia. So some judges have circulated a letter essentially saying that they will not hire students who are going to or have gone to Columbia as law students or as undergraduates. This is students who begin effective this coming fall, so they're fully on notice of this. They would not hire those Columbia graduates as law clerks. And that they think that Columbia has shown that not only is it a place where there's student disruption and anti-Semitism, at least in their view, and but that in fact that Columbia has shown itself to be a place that is not consistent in its views about speech. It's part to them of a movement in American universities to suppress conservative speech, or perhaps even maybe extreme conservative speech, but also mainstream conservative speech, while at the same time showing a remarkable amount of tolerance for what they see as extreme and bigoted speech on the left. So there is this letter. It's signed by about a dozen judges, I take it their argument is that this is what needs to be done in order to press universities into protecting speech on an even-handed basis and protecting students from what they view as abuses of claimed free speech, such as encampments, such as takeovers of buildings and the like. This follows on similar things with regard to Yale Law School and Stanford Law School, which have also involved some of the same judges over the last couple of years. But this time it actually says that they will not hire anybody who has gone to Columbia as an undergrad or as a law student. So, Erwin, tell us a little bit about what you think. We have our own thoughts. I've actually written a bit about this in the past, but I'd love to hear your thoughts.
The judges have the right to hire whoever they want as a law clerk, but what the judges are doing here is just wrong. It's wrong to punish the students for the choices being made by the administration. Here, what the judges are objecting to is choices made by the president of Columbia University. And why should the students be denied clerkships because of her choices? It's very different if we want to say that students who have done particular things won't be hired as clerks. But this isn't anything that the students did or they control. You were saying that, I'm going to use your words, Eugene, it was about protecting students. It seems so strange to say we're going to protect students by denying them opportunities.
Got it. That makes a lot of sense. And I should say that this is very close to the view that I expressed back in October 2022 with regard to the then boycott of Yale Law School, that, you know, the students are, we're about to say kids. They're not kids, right? They're young adults to us. Certainly, Erwin and my age, they're kind of kids. But let's say students are people. They're young people, but more broadly, there are people who just, most of them want to get an education. Most of them don't want to get involved in any of these things. They should be entitled to be neutrals. They should be entitled to be free of this kind of secondary boycott. And so I think, Erwin, I think what you're saying is absolutely right. And I'd love to hear also what Jane has to say, but I wanted to ask you a quick question. So one of the judges, Judge James Ho, who was the who has written about this and who I think has been involved in all of these boycotts, all three of them at this point, had a speech where he says, "Look, let's say a law school discriminated on the basis of race. Some law school that was known was discriminating against Black students, either excluding them altogether or just not protecting them against the various things the way that was protecting white students. Could a judge publicly refuse to hire from that school in hopes of spurring change?" And again, I think he meant not just could as a legal matter, but was it something that we should think would be a legitimate position for him to take? He says, surely a judge could do so. And if so, why can a judge stand up for colorblindness, for non-discrimination based on race? But he said not freedom of speech. Today he might say, but not freedom from anti-Semitism. That if we believe, and I know different people have different views, but if we believe that Columbia is giving a special break to these students who are expressing certainly very sharply anti-Israel views and in certain instances anti-Semitic views, why can't a judge say this is just like if Columbia was saying, you know, we're not going to be protecting Blacks, or we're going to giving special treatment, special positive treatment to anti-Black speech that we wouldn't give to others? So I take it that's the argument he would make just based on his past speech. I was wondering what you thought about that, Erwin.
I think that the judge should speak out against the law school that he believes is discriminating based on race. By virtue of being a United States Court of Appeals judge, he has a platform where his voice will be heard. And I would think in that circumstance, he would particularly want to hire Black students from that school because of the discrimination. And it may be that because he thinks that the admissions policy is so discriminatory, he doesn't trust any of the students who've been admitted and won't take them. But I think the idea that a judge is going to pressure a law school by hiring none of the students is simultaneously punishing the students at that school for something they had nothing to do with, and it's not going to have any effect in the school's policies. I assure you, as a dean of a law school, I'm not going to be pressured to change our policies by judges who threaten to not hire our students as clerks. I'll condemn those judges because they're unnecessarily punishing our students.
Got it. Makes perfect sense. Jane,
Yeah,
what do you think about all this?
I think I agree. And so maybe we'll have to go a little deeper to find places where we don't agree. But it seems to me that these judges, the only rational way I can understand it is if they've already fully given up on these particular universities or law schools, and they have decided that the entire class is basically corrupted, or they don't care about punishing a few individuals in order to affect some sort of worthwhile major change, which, you know, like Erwin said, is probably not likely to happen. But I just think that the premise is wrong too, that there are a lot of students at these schools that are asking for more intellectual diversity, that are taking risks by having Federalist Society events and whatnot. And so this is just the wrong way to try to reform an institution that still has some live roots, that's not thoroughly corrupted. Now, I am curious though what we all think of the boycotts against Harvard students that signed on to the letters shortly after October 7th. I'm forgetting exactly the content of the letters, but the letters were very, inflammatory, pro-resistance, we'll say. And there were some employers that were encouraging other employers to not hire any signers of these letters. Now we're talking about a set of people who, on one hand, they've actually done something to differentiate themselves and to show their judgment. On the other hand, what I've heard, and the reason I think maybe it might be a hard case for one or both of you, is that these are also still young students, especially at the undergraduate level. How much of a sort of social or economic punishment is the right, is normatively the right amount for something like this?
Yeah, I think these are in-kind different situations. In one instance, it's denying students opportunities because what the president of Columbia University did, not even what the law school did. And the other is denying students opportunities because of what those students did. Now, we can talk about when should an employer deny opportunities to students because of their activities. I would hope that generally employers wouldn't deny students opportunities because of their free speech activities, and that the employers would be very much wanting to protect student speech. But I also understand that there's a point at which an employer says, a student who has said certain types of things aren't the ones we want to present to our clients. And so I think it's a very different situation. As a dean, my position is we want to help all of our students get jobs. But I also say to students, in orientation as one else, that part of being a professional is you should be conscious of what you're putting on social media. You should be conscious of things you're saying, because you're going to be evaluated by that. And there's a limit to how much we can protect you.
Erwin, yeah, that makes a lot of sense. And I do think that these are very different kinds of questions, although each interesting in its own way. Erwin, what do you think about these laws in some states, including our own California, which at least purport to ban private employers from discriminating based on employees and applicants' political activity? The California statute, for example, has been interpreted quite broadly to cover advocacy of any candidate or cause. New York's statute is at least in its face rather narrow, where it just only focuses on basically electoral activities, although it also covers a recreational activity. Query whether tweeting is recreational activity. And then different states have different rules. Connecticut has its own peculiar rule. There's a Utah model. Maybe about half the states have such rules as to private employers. What do you think? Do you think, and we may one day have a podcast episode just about these statutes themselves, tremendously important, whether for good or ill, but they're potentially quite important. But for now, just tell me what you think. Do you think those make sense in this kind of situation, like that California employers on their face seem like they have to hire people, even ones who've expressed racist views, anti-Semitic views that some might think of as anti-Semitic or racist, even though the others may disagree?
I think it's a very hard question because you've got the employer's speech interests and the employee's speech interests. And there's remarkably little litigation under these statutes, including the California law, and very little on that question. So in theory, I like the idea that an employer can't discriminate against people on account of their ideology or views. On the other hand, when the employer says, we have to present ourselves to clients in certain ways, and we want to, as an employer, as an entity, convey a certain message, and we therefore need to control our message, how do you balance the employer's free speech interests against the prospective employees or the employee's interests? And that to me is a really difficult question, and one that hasn't been resolved under these statutes.
Excellent point. Maybe we can now turn to the other side, or one of the other sides. There are so many sides of the academic freedom discussions, which has to do with faculty. So, and I'm interested in both the First Amendment questions at public universities and also the free speech and academic freedom questions also at private universities that at least claim to be serious institutions that are devoted to academic freedom. And the questions really are, when may a university punish a professor? Possibly by firing, possibly by suspension, possibly by moving them out of certain classes and the like, because of what the professor has said. And usually because of what the professor has said has been seen as sufficiently offensive by people, either on the left or the right or wherever else, that they say, you know, we don't want this professor on the payroll, or we don't want this professor in our classroom and the like. And there are at least two dimensions here, or maybe three dimensions. One is, when may the university fire a professor based on what the professor said in his scholarship? A second may be based on what he said in his public commentary, tweets, let's say, or maybe some interview that's not directly focused on his scholarship in the sense of academic article. And third, based on what the professor has said in the classroom. So you've written extensively on this question. I'd love to hear your thoughts, both in general and perhaps how they may play out with regard to particular controversies that are in the news.
Sure. I think it's important to start by talking about the relationship between the First Amendment and academic freedom. I regard them as overlapping, but they're not identical. So as you point out, the First Amendment applies just to public universities, but academic freedom can apply and would to virtually any university that commits itself to it, public or private. Academic freedom is generally about protecting what the ability of the faculty member does in the classroom or in scholarship or in disseminating the scholarship. I would think that a professor going to a rally on a weekend wouldn't likely be protected by academic freedom, but it would be protected by the First Amendment. Within the context of how academic freedom and the First Amendment often overlap, let me try to address your specifics. I think with regard to scholarship, the key is the professor meeting the standards for scholarship within the field? That if there's a professor who's doing geology and wants to say that it's a flat earth, or a history professor denying the Holocaust, I think we would say that doesn't meet the standards of scholarship for the field. So inevitably, there are content-based evaluations going on. Hopefully, they are not viewpoint ideological evaluations, but scholarship does have to meet the standards for that particular field. Academic freedom doesn't protect your right to do poor scholarship. Teaching is the same thing. Academic freedom provides a great deal of latitude with regard to teaching, but it's not unlimited. If we assign someone to teach contracts and he objects and says, I'm not going to do that, I'm just going to come in every day and talk about the baseball pennant race, we can punish the teacher for doing that. If a teacher is teaching irresponsibly, teaching the material in a way that doesn't meet professional standards, academic freedom doesn't provide protection. In terms of public commentary, I think that it's likely protected by academic freedom, as well as the First Amendment, at least so far as it relates to disseminating the professor's area of interest. And I think so long as it's within the realm of professional responsibly commentary, it's also protected by both of these. The one footnote that I'd add that maybe more technical I get is that when it comes to public employees, there's generally no First Amendment protection for their speech on the job in the scope of their activities. The Ninth Circuit on the West Coast has said that it has an academic freedom exception to that rule, but other circuits don't. So again, this goes to the very technical relationship between the First Amendment and academic freedom.
So I'd like to ask, it seems to me that academic freedom, everything you've said about the relationship to First Amendment makes a lot of sense, but that academic freedom still might not be enough to get where we actually want colleges and universities to go and to stay. So you mentioned when you were describing how standards are going to be applied to faculty's scholarship, and actually maybe we could say the same about what they do in the classroom as well. Those standards, I think I have personally seen some corruption of those standards where there is viewpoint-based discrimination that is not based on, facts or evolution of evidence, but is instead ideological. I mean, just to give one example, I was reading over the complaint filed in U.S. District Courts in Florida against the Stop Woke Act, and I agree with the faculty plaintiffs in terms of their legal claim about the problems with that law, but as part of the background information that the complaint described, one of the faculty members explained that in their department, there is a consensus that merit is a white supremacist concept. And so that means that if there's a consensus, if you basically say something that does not align with the consensus, you have extra burden, right? You're carrying an extra burden, and maybe it would be wrong even to teach it in the classroom. And that's just one example. I think we could all sort of imagine examples that there may also be departments that have their sort of orthodoxies that are, right coded. I'm more familiar, and I think right now the problem is a little bit more with, with the left side. And academic freedom doesn't protect the university from an internal threat. So what do you think universities could do? In fact, academic freedom in a way makes this worse, right? Because then, it limits the sort of correctives that a university or even an outside, like even the outside government has at its disposal. So what do you think is the best way to combat this issue?
Inevitably, there have to be quality determinations within an academic institution. We're talking about hiring and promotion. It is based on the quality of the scholarship. Each of us in grading papers have to make determinations in terms of the quality of the paper. There's a difference when we're giving an A versus a B versus C, and so on. It never should be based on an ideological disagreement the way we're talking about it. I never in grading common law paper should care whether the student agrees or disagrees with a liberal or conservative perspective. But to say that sometimes this is abused shouldn't be taken to the conclusion that never should there be quality determinations. We should condemn the abuses. We should aspire never, even in a human system, to have that happen. But we have to accept that there have to be determinations about the quality of scholarship in deciding if somebody gets tenure, or the quality of a paper in giving a student a grade.
Well, I think we can accept that, but still see a systematic problem where if faculty decides who the next incoming faculty are, and they have an ideological litmus test, even if they're careful to, to make it, kind of a little bit opaque, then you can see this as a runaway problem or as a problem that gets worse over time, and that would need, that isn't just the occasional kind of random error.
I will oppose vehemently ideological litmus tests in hiring faculty. I will strongly support having ideological diversity in the faculty. But that said, inevitably we have to read the articles and have to decide, is this somebody who has scholarship of the quality to hire under our faculty? Is this somebody with scholarship of the quality for tenure? We can't avoid those determinations. We can only be committed as best we can that we're not going to make those determinations based on ideology in this sense.
Is there a good way to commit that? I'm sorry, Eugene.
No, Jen.
Is there a good mechanism for committing that and for really, sort of ingraining that in the culture even more strongly than it already is?
I welcome the suggestions. I mean, with regard to students, I send a message to students at the beginning of the school year. In fact, this time I did at the beginning of each semester, expressing our commitment that we be a place where all ideas and views can be expressed, that if you don't like an idea or view, bring your own speaker, but you can't disrupt, and that we all benefit from it. In orientation, which I was talking about earlier, I do a long speech about why students benefit from having all ideas and views being heard. Within the faculty appointments committee, try to instill that we're not going to make choices based on ideology, but we're all humans. And are we more likely to give positive evaluations of things that we agree with than those we disagree with? Yes, we can only just do our very best to try to be conscious of it and overcome those kind of biases.
So, Erwin, I think what you're saying makes perfect sense in many ways, perhaps in all ways. And one way of thinking about it is, in many aspects of First Amendment law, we have a requirement of content neutrality. But you can't have content neutral tenure evaluation, or if you would, it would be a parody, right? There's the old joke that you need to write more articles, even if they're not very good, because your colleagues may not want to read, but they find it easy enough to count. Well, that's a joke, because of course it would be a joke if there was a content neutral basis for tenure. If you write at least 5 articles, you get tenure, or 5 articles of at least 30 pages each with at least 300 footnotes. That's ridiculous. So you have to have this kind of content judgment. But I take it part of the problem is that if the judgment is based on kind of what is accepted in the academy, then if a particular part of the academy, could be a department, could be university, could be in fact the academy writ large in a country, is sufficiently ideologically skewed, then I take it there's a concern that, in fact, people who dissent from that orthodoxy will find themselves unprotected by academic freedom because their colleagues say, well, this is just bad work. Well, but why do they think it's bad work? Because of the human tendency to assume work we disagree with is bad. So one thing that I'm beginning to see, I think, in some state legislatures is the sense that kind of the blue faculties, maybe the dark blue faculties, are saying we get to make decisions about whom to hire and how to spend taxpayer money because we're the academy. And you, the red legislature, don't get to make decisions. You do get to pay for them. In fact, we insist that you pay for them. But academic freedom means we win. And it just so happens we're on one side politically, and you lose, you, the legislature. It just so happens you're on the other side from us politically. So what do you say to people who raise that kind of objection, the sense that academic freedom of faculty has become basically the freedom of universities, basically the university departments that are basically on the left, to just perpetuate themselves and then raise academic freedom, raise the First Amendment as an objection whenever the legislature, which may disagrees with them, may say, look, wait a minute, we need to counteract this tendency. That's, by the way, not a view that I'm terribly sympathetic with. I've filed a friend of the court brief opposing the Florida Stop Woke Act on First Amendment grounds. But I do think that's I think the strong argument on the other side.
Let me take what you say step by step. I believe that faculty have to decide who to hire subject to university approval processes, that it is the nature of faculty governance, which is integral to academic freedom, that the law faculty gets to decide who it wants to hire. Subject, of course, it's always reviewed by the campus to make sure it meets sufficient academic standards. At the same time, legislatures get to decide what they're going to pay for or not pay for. And my concern about it is often what happens is reasoning by anecdote. There's a particular instance that comes to light where a faculty is acting inappropriately, and there's a generalization from that. And I'm not going to tell you that faculties never act inappropriately. Any human body does, but I don't think we should be making policies based on the anecdotes of what's inappropriate.
So I do want to, I think one of the best parts of Stop Woke Act, since we've now all, I think, criticized parts of it, so the worst parts include the ones that basically create kind of an equal but opposite orthodoxy, trying to shove that into the classroom, or that try to seriously inhibit the operations of an existing department. On the other hand, another thing it does, though, is create centers at the existing universities, like at University of Florida here, it's the Hamilton Center, that basically has its own sets of majors and its own faculty, and it, resources this new set of departments well. And so that on the campus as a whole, and that faculty sort of gets almost sort of a fresh start, maybe with a more classical libertarian leaning initial faculty, and that's sort of an attempt to kind of right right size or, redistribute, I guess, the ideological backgrounds of the faculty across the campus. Does that seem like an intervention that is appropriate to either of you?
I strongly favor ideological balance within any faculty and with the faculty as a whole. I want my law school faculty to have individuals who represent the full range of viewpoints on the ideological spectrum. I want this campus to have that. What concerns me about what you say is if you create a center and say, we're just going to hire conservative faculty, does that then mean that other people aren't going to get hired on account of being liberal? And isn't that exactly the kind of viewpoint discrimination that I think we've all
well, it's
condemning?
right. So much of this depends on how the initial center, once set up, operates itself. The idea is, at least the legislation is designed to suggest that then they hire according to academic standards, the way they used to be back in the good old days before the other departments were corrupted. It doesn't quite say it that way, but that's the idea, I think. But I think you're right, absolutely right, that how the hiring is actually done remains to be seen, and might determine whether this experiment is a success. I'm still hopeful, but.
So, Erwin, I wanted to actually, I'm sorry, Erwin. I want to make sure you can respond to what Jane was
No, please.
So I wanted to shift the subject a little bit to the classroom. So one of the factors that arises with regard to the classroom is the teacher is teaching to a captive audience of students. Now, that term sometimes has been abused, captive audience, but here it does seem pretty apt
that the students are brought there by the university. They are sometimes required to be there if it's a mandatory class. Now, it's true they don't have to be at the university, but that's they do if they want to be able to take advantage of this experience, which for many people is just tremendously important. One of the most important benefits that the state provides, especially at state schools, it's somewhat subsidized. And then they're being graded. So you could certainly understand why students might be concerned about things that faculty would say. So the question is, should, despite that, faculty have the right to teach? To teach things. Let's assume it's not teach things that are factually false, but teach things that are at least plausibly defensible, that some people find quite offensive. Let me give you one particular example. It's from a case that was just decided on Friday by a district court. The case is Regis versus Haas. I'm not sure quite how to pronounce it. And this came out of the University of Washington. University of Washington, like many universities, have these land acknowledgments, in which in this case, faculty are encouraged to include in their syllabus a statement that acknowledges that the Coast Salish peoples remain part of the community of the Puget Sound region. Many of these land acknowledgements also sort of send the message that it's really their land that the white man stole, which may be true, but my view is always, that's true of virtually all land in the world. It was stolen by many, many people many times. I wouldn't include such acknowledgement in my syllabus. University of Washington people weren't required to, they were urged to, but Stuart Regis, as a faculty member in the computer science department, had his own statement. He says, I acknowledge that by the labor theory of property, the Coast Salish people can claim historical ownership of almost none of the land currently occupied by the University of Washington. He included this on his syllabus. And this caused a tremendous amount of kind of public upset. Students protested. Some students transferred out of his class, and he was disciplined in particular ways. So the question is, does he have a First Amendment right or an academic freedom right to include that? Now, one thing I do want to mention, one might say, well, he doesn't because this is a computer science class. So he has no right to include his own ideological beliefs about indigenous land in his computer science class. What makes that argument complicated is the university is strongly suggesting that everybody else include the opposite views in the syllabus. So then the question is, what is to be done? By the way, I should say, he wasn't fired, and maybe I shouldn't have said exactly that he was disciplined. His merit pay was held in abeyance during an investigation. So it may be that he himself, but then was reinstated. He was kind of admonished. It's an interesting question about whether he in particular was disciplined, but let's just ask whether it would be permissible to demand that faculty not say what he said on threat of discipline. A long question, Erwin, but
Sure.
I'd love to hear your answer.
I'll start with the particular example and then I'll go more generally. I don't think it would be permissible to discipline him for that under those circumstances. I think you put your finger on the key. To the extent the university was encouraging faculty to speak with a land acknowledgement, his doing a different version of it would seem to be protected. Otherwise, you really do have viewpoint discrimination by the university. I think it would be a much harder case if the university wasn't encouraging land acknowledgements and its computer science course, and he gratuitously put this in his syllabus. But in this circumstance, I'd rule in favor of the faculty member and say it's protected. I think the more general question is an enormously difficult one. On the one hand, we can certainly identify instances where academic freedom and the First Amendment wouldn't protect what a faculty member would do in the classroom. There was an unfortunate instance here at Berkeley where an instructor said that she would give extra credit to students who went to a pro-Palestinian rally. That, I think, is not protected by the First Amendment, academic freedom. It violates Regents' rules. On the other hand, no one can be completely ideologically neutral in the classroom. No matter how hard you try, your views will come forward. Maybe it's in the choice of the topics you cover, the books you choose, and it's not realistic to say that a professor has to be completely ideologically neutral. Where do you draw the line? At what point does it become proselytizing in a way that's inappropriate? That I find a very hard line to draw, but recognize there is a line there.
We should stick with faculty, but now put them back in the student protest context. So at some of the universities that have had protests that have wound up with encampments and with sort of intimidation and blocking students from reaching their classrooms and whatnot, faculty have been involved. There's also been some reporting about outside organizations providing support of various sorts. I'm wondering, well, let's stick with faculty for a second. Is a faculty member's involvement in a protest that goes against the rules of course they can be disciplined in some manner, but how, what would you do with the faculty, or what should a dean do with a faculty member that has that is engaged in the sort of illegal behavior that this alongside the students?
Earlier, we were talking about the relationship between the First Amendment and academic freedom. Imagine that a professor is participating in a rally on campus that violates the campus rules with regard to time, place, and manner. I don't think academic freedom likely would apply there. It's not about the scholarship, the teaching, the dissemination of ideas. Nor do I think the First Amendment would provide protection in terms of if it is a content-neutral time, place, manner restriction that serves an important purpose and leaves open adequate alternative place for communication, the campus can have that. And those who violate those rules can be punished. The faculty member could be punished. The students can be punished. To me, the hard question that campus faces today isn't a legal question, but a pragmatic and political question. When do they want to enforce those time, place, manner restrictions? There's an encampment here at Berkeley that violates campus rules. The campus could certainly exclude it, have it taken down, punish those who are there. These are content neutral rules. The campus has made the choice for pragmatic and political reasons to let the encampment be. Other campuses have made a different choice, but I don't think that's a legal question. And I don't think there's been enough attention to the distinction between the First Amendment law, which would allow the faculty member in your hypothetical to be punished, and the pragmatics and politics situation, which go to whether the faculty member should be punished.
I agree with that. But I also assume that the standard for punishing a student in some way is probably going to be different from a faculty member. So I'm wondering what sort of, deterrent should be sent when faculty members do get involved in protests that, are that are advocating a position that the faculty member genuinely believes in, but that nevertheless they wind up violating rules or laws in order to help progress.
Really hard question. And
Okay.
of course, so much is going to depend on what that faculty member did. How serious is the infraction? There's some infractions that are relatively minor, and there are some that involve vandalism, destruction of property, and violence, which are very serious. And you're right, of course, it's easier to suspend or expel a student than it is to revoke a tenured professor's tenure. So you're dealing with different ability to impose sanctions, but it all depends on the context and the circumstances.
Do you think it changes the nature of the student's speech? And maybe this relates also to the outside influences. So I think one reason campuses give a lot of latitude to student encampments even, and protests and things that violate technical, both trivial and non-trivial rules, is that when they are, if they are sort of self-organized and grassroots, it's an opportunity for students to sort of test out their voice. Does outside influence or faculty influence change the nature or change your assessment of this?
No, because it's the speech that's protected by the First Amendment or of a faculty member, the speech that's protected by academic freedom. I worry about a standard that focused on whether it's grassroots or self-organized as opposed to outside influence, because we're never going to be able to know what is the outside influence or be able to know the extent of it. Who's paying for all the tents on the campuses right now? No one knows the answer to that. To what extent are there outsiders who are part of organizing this? Is there communication among the various groups? So to me, the question is, under the First Amendment, under academic freedom, what is the school allowed to do? And then separately, what should the school do?
These are all excellent points, and we agree on much. On many issues, Erwin and I are pretty far apart, and Jane is probably far apart from
Somewhere.
both of us
Right.
this as well. But on these questions, I think we agree, possibly because we're both all mistaken together. But I like to think that it's a sign that we're actually in the right. But let me ask you one particular question about the enforcement discretion point that you mentioned. It's true, enforcement discretion is in some measure inevitable. You're never going to have a situation where every rule is always completely enforced. But especially when the violations are really flagrant. One question that arises is, once some group is cut slack, once they're exempted from some rule, possibly but just because, well, practically speaking, it's very difficult to stop them, but possibly because there's a lot of sympathy for their perspective, at least among some important constituencies. Doesn't that mean that other groups, including ones we may all quite loathe, should be entitled to the same slack, or else it won't be a content neutral or viewpoint neutral rule anymore? I was reminded of a case, you probably very well acquainted with it. It's a Ninth Circuit case called Hoy v. City of Oakland, and it involved an ordinance that purported to limit certain kinds of activities outside of abortion clinics. And the city defended it as being just a content neutral ordinance. And then a very liberal panel, I think the opinion was by Judge Stephen Reinhardt, arch liberal, says, well, in fact, there's solid evidence that the ordinance was not enforced against pro-abortion speakers who wanted to speak out to oppose anti-abortion speakers. It was only enforced against the anti-abortion speakers. And so now they can no longer defend it as a content-neutral ordinance. So I wonder if you cut slack to a group of pro-Palestinian or anti-Israeli protesters, what happens when somebody says, we want an encampment to protest the genocide of the unborn? We are anti-abortion, that's what we want to do. Or we want an encampment to protest the oppression of whites by the liberal elites. Maybe we're white supremacists, or we're not really, but you think we are white supremacists. Well, we're entitled to the same treatment, the same slack that was cut to others as well from these content neutral rules. Is there a danger that refusing or declining to enforce the rules will stop one from being able to enforce them in the future?
Yes, absolutely. And I'll give a specific example. Sather Gate leads into the Berkeley campus. The administration has decided to allow pro-Palestinian students to block the main Sather Gate. There's still small entrances on each side. Once they do that and say, notwithstanding rules prohibiting this, we're going to permit it, they then have to let any group do the same thing, because they can't say, we're going to allow this group in this message, but not a different group with a different message. Now, I understand pragmatically why they wanted to allow this, but the consequence of that in terms of the First Amendment is when your anti-abortion group or make it any group wants to do the exact same thing, they've got the First Amendment right to do it as well.
So does that sort of wear off over time or something? Is that, it seems sort of inconceivable that once some specific area is encamped and tolerated for, more than a day or something, that the university has therefore waived all future rights to enforce the rules.
I don't know where you draw that line. I certainly think in a temporal sense, if next year another group wants to come and block Sather Gate in the same way that this group did for a long period of time, then you got to allow them to do so.
Agreed.
5 years from now, 10 years from now, can they point to this example? I don't know where you draw that line, but there certainly has to be a content neutral application of the time, place, and manner restrictions. And once the campus is saying, we're not going to enforce our time, place, manner restrictions for pragmatic reasons now, they've got to follow that at least for the foreseeable future for other groups with a different viewpoint.
So that makes tremendous sense to me, Erwin. And we've been at this now, I think, for almost an hour. We usually do 30 or 40 minutes, but one of the great things about a podcast is it's not like a primetime broadcast where we fixed a particular time limit. And this has been such an interesting conversation that I'm very glad that we've had it and we've had it run over. I do think that we need to let you go, Erwin, but also I think our audience, I'm afraid, do have a limited attention span, even for such interesting topics. So, Erwin, I just wanted to see if you had some closing words that could end this episode for us.
I just want to thank you for having on and for this discussion. Issues of free speech in schools have been there as long as there have been schools, but they seem so salient right now. And I think since October 7th, we've seen very difficult issues arise. Let me just say, I think that this is different than what we've seen on campuses before. I was in college during the Vietnam War and participated in anti-war protests. The students were overwhelmingly on one side. The students are very deeply divided right now. And the division reflects matters that go to the identity of the students, often in a very personal way. And maybe to end with what we were just saying, I think the choices that campus are making right now on how to handle this are going to have enormous effects on what campus can and should do in the future.
I think that's absolutely right. Erwin, thank you so much for coming to join us And I wish you all the best with your many travails, both the very specific ones we talked about and just the inherent travails of being a dean at any time, or dean at Berkeley, I would think, especially, any time, but especially in these times.
Thank you.
Erwin, it's been a very great pleasure. Jane, it's been a very great pleasure, as always, talking to you. Audience members, great pleasure talking to you. And we'll be back probably with our next episode, probably in a couple of weeks.
Thank
Thanks all.
you.
Thanks.